All right, I'm going to get everyone checked in. As I call your name, if you could confirm. All right, sorry folks, having a couple technical difficulties this morning. I think I have it all sorted. I'm going to go ahead and get everyone checked in here. Again, if you do have a name on the screen, if you confirm that that name is correct, or give me your full name, and then tell me who you're representing here today, whether you're an applicant, an owner, um, or a neighboring property owner, or someone else. So I'll start with Kelly's iPhone.
Yep, that's me, Kylie O'Connell. I'm the homeowner. Thank you for your time today.
All right. Welcome, Kylie. And we have Matthew Evans.
Yeah, that's me. I'm the architect representing the owner.
Okay, excellent. And I see that we have Wes Menzel here from the zoning department. Welcome, Wes. Also, not JP Burley, I know that. Is it O'Connor? Is that right? I'm sorry.
This is Quinn Marker. I'm here on behalf of the Woods. Yeah, sorry about that. We're in my conference room. I think the name just defaulted to JP, so I'm Quinn Marker.
Sure, no problem at all. And you are an attorney representing the Woods, correct?
That's correct.
Okay, great. Welcome. All right, and then we have Anthony Wood with us. Could you tell me who else is with you today?
Laura Wood.
Okay, great. All right, and neighboring property owners, correct?
Correct.
All right. All right, welcome. On the applicant owner side, are we expecting anyone else to join us here today?
No.
To Mr. Evans or O'Connor? Okay, great. All right. Let's go ahead and get started. I need to read through our hearing script. This will basically just cover the procedure for the hearing, and then we'll jump into it. So this is the February 14th, 2024 session of the zoning hearing examiner docket. The case before us today is case number ZH202340001. The purpose of this hearing is to allow applicants and any potential opposing parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any opposing party wishes to offer must be presented at this hearing. The hearing will proceed as follows. I'm going to start by asking the zoning plans examiner, Wes Menzel, to do a little table setting for us. And I'll ask that Mr. Menzel just give a very, very broad, high-level overview of what exactly the relief is that the applicants are requesting. After that, I will then turn it over to the applicants themselves to first present their case. I'm going to set some time limits since I have a 12 o'clock today, so I'm hoping that the applicants will be able to tell us about their case and make their presentation within 15 minutes. Of course, don't have to use all of that time, but I'm going to set sort of a ceiling there on that. I'll keep track of the time and give people updates as we go through. I will then turn it over to the attorney for the Woods to ask any questions of the applicant or owner or anyone else that's testified at the hearing. And I'll allow up to 10 minutes for that. I'll then turn it over to Wes Menzel to provide any testimony in addition to his staff report. After he is complete with that, we'll move over to Mr. Marker and the Woods to provide any testimony or present any witnesses or make any arguments they would like to make about this particular application. And I'll allow about 10 minutes for that as well. I'll then go back to the applicant. I'll then allow Mr. Marker to make any closing statements or closing remarks. And finally, we'll finish with the applicants making any closing statements or remarks, and I'll limit each of those to about 5 minutes. So I will, again, remind you of the time as we go through and the procedure, but essentially we're going to start with with Mr. Menzel giving us an overview, presentation from the applicants, any questions from Mr. Marker back to Mr. Munzel for his staff report, summary of his staff report. We'll then go back to Mr. Marker for them to make any arguments on the application. Then we'll start closing statements. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may limit or exclude, I may interrupt any speaker to ask questions or to make any comments. In the event of any technical difficulties, which we've already seen a couple of, I'll do my best to troubleshoot those on the fly, but to the extent there's some defect that prevents us from meaningfully going forward with this hearing, I may continue or postpone the hearing at my discretion. Okay, last thing to do is just swear in all of our witnesses. So if you intend on providing any testimony here today, asking any questions, making any comments, really doing anything other than just strictly observing, and you are not an attorney, then the zoning code requires that I swear you in. So I'm going to go ahead and collectively do that now. If you could all raise your right hand and answer out loud. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay, great. All right, Wes, if you could please just give us just a brief high-level overview of what the requested relief is.
Sure. Good morning. So the applicant's proposal is to construct a pergola type element between the existing detached garage and the main principal structure of the house. And based on that structural element that connects the two, the accessory structure and the principal structure, then by default, the existing garage accessory structure becomes part of the principal structure and has to follow the principal structure setbacks. So with this being a corner lot, the front is on, what street is that? Crestwood. And therefore the rear is the opposite, parallel line on the west. And so based on that, the rear setback is required to be 35 feet. And I believe there's 3 feet on the rear. And then likewise on the side, the north side would require to be a 7-foot setback for a principal structure. And the garage is also 3 feet to the property line there. So that requires the variances I outlined, a rear setback variance of 3 feet and a side setback variance of 4 feet to the existing detached garage structure based on the SF's 6 requirements. So
Okay.
That's kind of a high level summary.
Sure. Okay. So because the pergola is going to attach the existing garage to the existing house, that then triggers the setback standards for a principal structure applied to the existing garage. And
Correct.
that is a 3-foot north side setback is what they're requesting, and a 3-foot rear setback. Is that right?
That's right.
Okay, great. I'm going to turn it over. With that, I'll turn it over to the applicants. You all can orient your presentation however you'd like. One of you can speak, both of you can speak in any order you'd like, and I'll start the clock now. Table's yours. The floor is yours.
I can start, Matt, and then let you take over any details. But I'm Kylie O'Connell, the homeowner. That is a good summary of what's going on. I think my impression is, if we wanted to build the pergola and comply with the existing zoning requirements, we could still build it. It's a section of 12 feet as the gap. We could only build an 11-foot. We couldn't do the final 12 inches that actually connect to the garage. So that's kind of the crux of the issue, I guess, is if we can get those last 12 inches to actually connect the pergola structure to the garage. And I'll turn it over to Matt, but we've spent over $600,000 in renovation improvements to the house, I think, in good taste. And I went around to our immediate neighbors and got all of their signatures on this and submitted that as part of the application. So all of our direct neighbors been spoken to and talked with. I haven't talked with the Woods. I haven't met them. Sorry if I didn't stop by your house, Anthony and Laura, but happy to answer any questions and hopefully get you guys comfortable with what's going on.
Okay.
I just want to restate and just a little more detail to that. The zoning code allows for a detached for a pergola that could extend within 12 inches of the accessory structure and still have it be considered an accessory structure. This is not by any means a space that could be enclosed in the future. This has no foundation system in it. It's not a future space that can be conditioned. It's not a space that can be, like I said, easily enclosed or insulated or any of that. This is primarily a roof structure that connects between the existing house and the existing detached garage. The existing house, the principal structure, does not have a garage that's attached to the building. And the owner would like the comforts that are pretty much in that area provided to a lot of residents, where they can access their garage directly from a conditioned space. They won't be able to do that still, but they will be able to get out of the rain. Now, what we'd like to do is just extend this roof system over to the garage, so that last 12 inches of space doesn't have to be open and can provide them the protection from weather. And that, of course, is weather that's dropping straight down. This doesn't provide them any other protection other than rainfall. I want to make that very clear, that this is not an enclosed structure. It's only a roof system. There's no walls whatsoever. That's it.
Okay, great. Thank you. All right. Did Mr. Marker, did you want to ask any questions of Mr.
I don't
O'Connell
have-
or Evan?
I don't have any questions. Thank you, Mr. Examiner.
Okay, great. Let's go over to back to Wes. Wes, would you like to add any testimony in addition to your staff report?
No, I think that the written text I wrote is fine for now. So
Okay,
thanks.
great. Thanks, Wes. All right, Mr. Marker. Again, I'm sort of pretty liberal on how you want to orient your presentation. Or, I mean, if you want to turn the floor over to the Woods to provide some direct testimony, or if you want to do it more of a direct examination where you ask them questions, it's completely up to you. So, floor is yours.
Thank you, Mr. Examiner. I said earlier, but my name is Quinn Marker. I'm an attorney with the law firm of Suter LLC here on behalf of the Woods. So my plan, if it's all right with you, Mr. Examiner, is that I would give a kind of brief summary of why we're here today, and then turn it over to the Woods for some testimony, and then just sort of wrap up with some thoughts.
Sounds great.
So I'll start by saying that, the Woods, I think it's come up, are at 3459 Principio, so not immediately, next door to the O'Connells, but know that this issue, they've been before you before, Mr. Examiner, with this sort of issue with structures near the property line. And I'd like to also start by saying that the Woods' concern is not the pergola itself. In fact, our argument is that a variance really shouldn't be needed in this situation, and that it's really just an issue of how the zoning code is being interpreted and applied. And we feel that there are some, downstream impacts that could result in the neighborhood by applying that default section we talked about, 142101B, about that minimum distance from the principal structure. Because the concern is that this interpretation could down the road give someone the opportunity, to build what was an accessory structure garage up to 35 feet tall. So that's the concern. That's why we're here today. And to provide a little more context to that, I'd like to turn it over to the Woods to talk about, some of their on-the-ground concerns as neighbors. So, Mr. and Mrs. Wood, if you could you please introduce yourselves and provide your address for the record?
Yeah, Anthony and Laura Wood,
Laura Wood.
3459 Principio.
And how long have you lived at 3459?
Since 1999.
And could you, briefly talk about, your concerns with the application as a neighboring property owner and the potential of having large structures near your property?
Well, I would say, first of all, I would emphasize to the O'Connells that we completely support what they want to do. We have no issues at all. We think it's a perfectly normal, some things you would want to do for your house. I hope they enjoy it very much. But we were concerned that you can create this attachment with unconditioned space to this, this detached garage, because we had just gone through a variance hearing with our neighbors, and the fact pattern seemed to be somewhat similar, only in the fact that they wanted to create this attachment between their main residence and this detached garage, which was sitting, 4 foot off our property line. So we're a little bit confused, and I guess we're concerned. I mean, if I'm our neighbors, who we had, this dispute with the variance, we don't know why they couldn't just go back and say, well, we'd like to create, this attachment of, and then go ahead and have their detached garage become part of the principal residence. That's all that's all our concern is. And I'm so sorry that we're here.
No, I understand. Wes, if I could, Mr. Marker, briefly go out of order here. Wes, do you have a response to that?
Well, I would say that under the scenario of an applicant connecting their detached garage to their house in some manner, and then later on wanting to expand the garage massing, they would have to conform to the setbacks. They would have to come in for a variance for that second floor addition, because the new facade on the second floor is 3 feet from the property line, or, I don't remember what it was in your case for the woods, but the neighbor of the woods. But they would have to come in for a variance for that. And that would, allow for the neighborhood to review it, and a technical review and such. So that would be the required process for anything for that type of scenario.
Yeah. If, the accessory structure side setback or just setbacks in general are much smaller than the principal structure. So I think I'm remembering correctly that that accessory structure next to the woods would encroach on the principal structure setbacks. So they would have to come in if they did an attachment and go through a variance process. And if they wanted to add the height, the principal structures are allowed at 35 feet and maintain those accessory structure setbacks. I think they would likely run into some of the same problems that they had in their initial application. Hopefully that makes sense. It is a little confusing with the accessory structure setbacks, but that's essentially how it would work. And they would, like I said, I think they'd run into some of the same problems there. But if there was some way that they could build an accessory garage, and they wanted to build it 35 feet, and it was within 1 foot or connected by a structure like this with 1 foot and complied with the side setbacks, that would be something they'd be able to do potentially without any zoning relief. And that's sort of out of our hands, because that's all written directly into the code, and that's how the code reads. So without an actual zoning code change via some legislation, there'd be nothing we could do to prevent them from doing that. So I don't know. Hopefully that shed some light for you guys. Did you have any questions based on what me and Wes just said?
I think the concern from our perspective was that by applying that default section and then requiring an accessory structure to have a variant, because it is becoming part of the principal structure simply by virtue of that connection with the pergola, that then the variances are there for a principal structure. So in our view, it seems it could arguably give a right to say, okay, this is part of my principal structure now. I have unused height. I'm already complying with the setbacks. I already have a variance for that as a principal structure. So that's the that's the concern.
Yeah, and that wouldn't happen. I mean, because this is actually a good example. I mean, this is an existing structure that complies with the accessory setbacks. But once it becomes considered a part of the principal structure, it no longer complies with those setbacks. So again, if that accessory structure next to the woods complies with the principal setbacks and they connect it, then they are permitted by right to raise that height. But if it doesn't, if it only complies with the accessory structure setbacks, then they would need to come in for a variance, and they'd be subject to the same variance standards either way. So
Thank you.
yeah, and I'm happy to talk to you guys some more offline about this, and I'm sure that Wes and the zoning administrator as well would be happy to shed some more light on this, and talk through potential scenarios. Be happy to do that.
Thank you.
Sure.
If I may,
Yeah, Wes, did
David,
you want to add something quick? Yeah, go ahead.
I just wanted to add a caveat that there is a scenario where if an existing accessory structure is wanting to be renovated into a accessory dwelling unit, there are different standards for height for that.
Right.
So that that's not happening here, but I'm just saying, like, that's something that everyone should be aware of, that might be something that happens later on, anywhere in the neighborhood. But
Okay. Wes, are you saying that that's a potential loophole where someone could not be subject to the principal structure setbacks?
yes, if the accessory structure is 3 feet away from the line, they're allowed to go up to the height allowed under the ADU clause. I think it's 25 feet height. There's a whole bunch of other rules too, but like,
But-
that is a fairly new
Yeah.
zoning code update.
Right. And that is regardless of its distance to the principal structure. So again, not totally analogous to what we're seeing here today in this case, but yeah, that is the ADU standards are in place now, and they're in 142106 for anyone interested. But yeah, that can happen as well.
thank you for that context. I think the way we were thinking about it, and the way we had been discussing it, seemed like, there were alternative interpretations that could be applied in this scenario where, if the variance for the setbacks was there and it makes it a principal structure, then that right, could arguably arise. And in talking about this with the woods, we were talking about, alternative readings of different sections of how a pergola could be viewed. And in my view, there are, at least 2 alternatives, ways to a pergola can sort of fit into that 142101 section. The first being, as a breezeway, where that is defined at 140101B9 as a roofed passageway connecting 2 structures. And as a breezeway, seemingly you could argue that no variance would be needed because the garage and home remain the accessory structure and the principal structure. Second alternative would be that exception in 142101B, accessory structures other than fences and walls within 1 foot of the principal structure, that a pergola could be seen as akin to those fences or walls, and that it's effectively doing the same thing. It's sort of kind of shielding that area, if you will. And then in that instance, again, both would remain accessory and principal. So in either scenario, we think that, a variance really shouldn't be needed to kind of create this other principal structure or addition to the principal structure. But again, to reiterate, as Mr. Wood mentioned, the Woods are not opposed to the O'Connell's pergola. Our thought is that this could have some negative consequences down the road in this application in the neighborhood. So we'd ask Mr. Examiner that, we think a variance shouldn't be needed, but the permit should still issue. But, the second ask would be to in the decision, include some language sort of expressing what you said in this hearing, that, you know, this isn't a shortcut to be adding additional height onto what was an accessory structure, but is now becoming principal structure.
Sure. I understand that, and I'll certainly consider it when writing the decision. Wes, do you have any from the zoning department's perspective, what actually makes this substantial of enough connection between the accessory structure and the principal structure to combine them like this for our setback calculations?
I'm not really, I mean, I think the definition of pergola is beyond what is allowed as an exception that was just noted, like, and it's actually connected to the wall of both the garage and the house. I mean, the exceptions noted in 142101 are like an arbor, flagpole, trellis, like those are kind of standalone elements that are by themselves in the rear yard or side yard. Whereas this, I think, is beyond that standalone structure concept. But without doing a bunch more research, I can't really provide any more information about that interpretation.
Gotcha. Okay. Generally, though, the fact that they are structurally connected in some way, and they're not standalone, is what the zoning department, as a general standard, has been using.
Yes.
Okay. All right. Anything else based on my questions from anyone?
I only have one comment to add to that, is that if you're looking for a distance variance, why not, obviously with every project and every application, you treat them separately. This by no means would create precedence for other approvals because you treat each case separately. But why not just state that it's still an accessory structure and get a variance from the 12-inch distance to 0 inches? So that then would not make the accessory structure a part of the principal building. So all you'd have to do is say the variance is from the section of code requiring 12 inches, and you're going to get a variance of 12 inches to make it 0.
Gotcha. Well, I think the concern is that by getting the accessory structure included as a principal structure, you then get the height limits of the principal structure.
But this would not change what that space is designated. It would remain a accessory structure after the findings and the approval of the variance. You're just getting a distance for the connection. So you're still connecting it, but you're still maintaining that it's an accessory structure by the approval of the variance. It would not change this to you're not looking for rear yard increases or decreases or anything like that. You're just looking for a variance from that 12 inches. That's it.
Well, that's an interesting point, and yeah, I think it's something that I'd be happy again to put some more discussion into offline.
Yeah.
If anyone would like to take advantage of that. For now, why don't we go ahead? If there are any closing remarks, let's do those, or if we're all ready to finish up.
I'd like to say that the sooner we can get this approved, I'm sure the owners will be eager to get moving. I know that they have other improvements to the house that they're working on, and they probably like to get the contractors out of their property as quickly as possible.
Okay.
That's definitely true. I can attest to that. And speak for my wife, I think, pretty safely on that. Yeah, thank you guys for the time today. Woods, thanks. I understand kind of where you were going with this, and appreciate the fact that you were would be happy for us to get this variance in terms of what we were looking to accomplish, or you want us to be able to do what we're trying to do. I appreciate that as well. So I guess this, David and Wes, is there any, I think we're all on the same page. Is there any lingering concerns over this setting, precedent, or any, reason why this shouldn't be approved? I just want to make sure that we're kind of on the same page before we adjourn here.
Sure. Let me ask Mr. Marker if he has anything else. I believe that you already sort of made your closing remarks in terms of consideration in the future.
That's right, Mr.
Is that
Chairman.
right?
That's correct. And we understand that these aren't, precedent-setting decisions, but just to be able to sort of note this, discussion and this distinction for the future, when time when this comes up, because we understand this is a common thing that happens.
Sure. Thank you. Okay, so let's leave it at that. We'll close out the hearing. Based on the application materials, the staff report, and the testimony here today, I am going to approve the application. So Mr. O'Connell, it will be approved. I need to formalize that approval in a written decision that we've talked about a little bit here already today. That typically takes about 2 weeks. I'll do whatever I can to get that out to you as quickly as possible. But I am, to Mr. Marker's point, going to be sure to include the considerations that he's raised. There's some precedent that is set in these decisions, but I think Mr. Evans stated this as well. I mean, every single application has to be looked at based on the property and the dynamics and the house and the site plans of that individual application. So it's really hard to treat two separate projects exactly the same. But I will get into that in a little bit more detail in the actual written decision. As soon as you have that decision, Mr. O'Connell and Mr. Evans, I know Mr. Evans is familiar with this process, but Wes is able to approve the zoning permit on his end. So hopefully at that point, you all are able to move forward. I will say again that if anyone would like to talk about any of the details or the precedent, or have a conversation with the zoning department, I would encourage you to reach out to them to ask them about their interpretation of 140106 and what sort of the parameters are of their interpretation of that. I'm also happy, after this decision has been issued, to discuss this case or any other cases with anyone that would be interested. So unless there's any other questions right now, I think we are ready to adjourn. Okay, great. Well, hope you all have a wonderful day. Thank you all for your time and your testimony, and we're adjourned.
Thanks, David.
Thank you.
Thank you.
Thanks, guys.